Hi warriors, this is Jaylyn, my legal warrior, and today's segment is going to be about controlled substances and how it affects child custody and visitation. Now, controlled substances are defined under California Uniform Controlled Substance Act, and it can be found under section 11054. And actually, let's just go ahead and take a look at it. So the Uniform Controlled Substance Act has a list of controlled substances that the court will not allow, and they will scrutinize, that the court will scrutinize if ever presented in any of your child custody and visitation proceedings. And so you can go through the different schedules, as they call them, and find out whether the controlled substance that you are using is going to be scrutinized by the court. And this essentially stems from, if you remember from our former video, we did bring up the Family Court Section 3011. And within Family Code Section 3011, there was a particular section that had brought up illegal and continual and habitual use of controlled substances. And as we know, in the state of California, the usage of cannabis, medical marijuana, is legal. So when we look at the habitual and continual illegal use of controlled substances, most parents think that because it's a medical marijuana, they are using medical marijuana, that is not considered illegal use of controlled substance, because it's not illegal in the state of California. It's still illegal federally, but it's not illegal in the state of California. But the most important terminology in this sentence under Family Code Section 3011 is the habitual or continual use of the controlled substance in a way that it is in an abusive manner. So let's just read this section really quick. The habitual or continual use of controlled substances, the habitual or continual use of alcohol, or the habitual or continual use of prescribed controlled substances by either parent. Before considering the allegations, the court must require independent corroboration, including but not limited to reports from law enforcement agencies, courts, probation departments, social welfare agencies, medical facilities, rehabilitation facilities, or other public agencies or nonprofit organizations providing drug and alcohol abuse services. And the word controlled substances are going to be defined under California Uniform Controlled Substance Division Act. And like I showed you earlier, section 11054 onwards will have the list of the controlled substances. Now, in terms of Family Code Section 3041 in the child custody and visitation proceedings, if the court does find that there is evidence to show the continual or habitual illegal use of controlled substances, then the party, the other parent, the one that's complaining that you are doing this, can ask for the court to drug test you in order for it to determine child custody and visitation, what's in the best interest of the child. And that's where Family Code Section 3041.5 comes into play. So it says, in any custody or visitation proceeding, the court may order any person who is seeking custody of or visitation with a child who is the subject of the proceeding to undergo testing for the illegal use of controlled substances and the use of alcohol if there's a judicial determination based upon the preponderance of evidence, which is a very low threshold, that there is a habitual, frequent, or continual illegal use of controlled substances, or the habitual or continual abuse of alcohol by the parent, legal custodian, person seeking guardianship, or person seeking visitation in a guardianship. This evidence may include, but it's not limited to, a conviction within the last 5 years for the illegal use of controlled substances or possession of a controlled substance. The court shall order the least intrusive method of testing for the illegal use of controlled substance or the habitual or continual abuse of alcohol by either or both parents, legal custodian, basically anybody that's seeking visitation. And if the substance abuse testing is ordered by the court, then that testing shall be performed in conformance with the procedures and standards set by the U.S. Department of Health and Human Services for drug testing of federal employees, which is essentially a urine test. The parent, or whoever it is that's requesting visitation, who has undergone drug testing shall have the right to a hearing if they request it to challenge a positive test result. A positive test result, even if it's challenged and upheld, it's not by itself going to constitute grounds for an adverse custody or guardianship decision, meaning that the court is not going to strip you away automatically of your custodial rights. However, they will use it to determine what's in the best interest of the children when they weigh all of the relevant factors, which is in that Family Code 3011, and there's a whole video on it, and we just briefly discussed it herein. Now, the results of this test has to remain confidential. Any person who has access to their test results cannot disseminate any copies or disclose information about the test results to any person other than the person who's authorized to receive the test results, and they may not be used for any other purpose, including criminal, civil, or administrative proceedings, except to assist the court in determining, for the purposes of the proceeding, the best interest of the children and the content of the order or judgment determining custody or visitation. And the court can order one or the other or both parents to pay for this drug and alcohol testing, and again states that controlled substances are under the California Uniform Controlled Substances Act. Now, there are several published case laws about whether medical marijuana usage can negatively impact a parent's visitation rights. And simply, the answer is yes, it can negatively impact a parent's visitation rights. However, just the mere use of medical marijuana is not enough to alter a parent's visitation. So a complaining parent has to show that there is a specific or defined risk. For example, when a parent does use medical marijuana and their demeanor towards the children is negative, the best way to defend yourself around this allegation is to show the court that you never smoke around the children, you don't smoke on the days that you have the children, and you store the medical marijuana in a lockbox in your home during your parenting time so the children do not have any access to it as well. And we understand that medical marijuana can come in different forms and doesn't have to be smoked. So in any way that you do use medical marijuana, you would still need to show the court that, again, on the days that you have them, you are not using medical marijuana in any way, shape, or form. Now, if it's medically necessary for you to use marijuana on the days that you do have the children, then you're going to need to speak to your healthcare professional about how to resolve this so you could adequately present it to the court. Thank you, warriors, for taking the time to subscribe to my channel and to share this content, because you just never know who might actually be in need of this, especially during COVID-19, where this might be a new issue amongst parents that are caring for an infant child or a toddler, and the court is not available to resolve this particular issue, and the parents are being told that this is not enough of an emergency to bring it to the court's attention. And that's going to be between, you and your attorney, whether you make that decision, whether you define that as an emergency within the family code and the California rules of court and the local rules. Thank you, warriors, again, and we hope that you share this video, subscribe to our channel, and we hope that you're staying safe during COVID-19.